Yes. Yes.
Yes, my lord. My lord, the Honorable Single Judge has dismissed this writ
That's
application.
right. That's why you are here in appeal.
Yes,
Now,
yes, my lord.
were you defendant in title suit number? What is that? What
Yes,
is the
my lord.
title?
Suit is pending, and now they have filed a
176.
petition for withdrawal of that suit.
They
That is a
filed a petition for
subsequent
withdrawal of the suit.
withdrawal of that suit.
Why?
Actually, my lord, actually this is subsequent development. During they
Then
filed this.
why are you challenging this? It appears that
I did not file the suit. I was implemented as
I've asked you the first question. Were you the defendant in that suit? So
yes.
you have not filed it. You're only contesting it. Now you say that they are Deepak Agarwal and who is he? Who is the other person?
Deepak Agarwal and
Anil
seven.
Agrawal.
Anil Agarwal.
Anil
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 Agarwal.
Agrawal.
Deepak Agarwal and Anil Agarwal. They have withdrawn. They have made application for withdrawal of the suit. Have they
Actually,
entered into some kind of
background,
settlement?
sir, I maybe allowed
You
to.
have given
What
a
is the
new twist.
background? Why they have filed the petition for Allah?
You have given a new twist to the story. Now, if the moment you say that they have withdrawn the suit or they are attempting to withdraw the suit, that means you have entered into some kind of an arrangement with these people who are wanting that property to be declared a public trust, right? So, if you have entered into settlement, why challenge this order?
They have taken the position and they are locked out. I am
So
out
therefore,
of the premises.
no, but what was the goods? How do you say that they are withdrawing the suit?
Actually, what happened, my lord? My submission, I did not file the writ petition praying for declaration of title, right and title under Article 226. My case was whether only filing a suit can evict a person
No,
from the premises without any order.
that cannot be a prayer under Article 226. That
Uh,
declaration of law you are asking under 226.
The restoration of the
You have prayed for a direction to. You have asked for a direction to the state governments to restore the possession of yours over a two-story building standing over the
and
over
not to
particular,
interfere.
which was vacated by force because one of the ministers was in contact with Deepak Agarwal or Anil Agarwal and he removed
I have
that.
annexed the letter with the writ petition as Annexure 14 and without any order from any court, from any corner for eviction. My lord may kindly appreciate that even a judgment letter.
Can a writ court restore possession? Can a writ court tell you that forget about all those proceedings of evacuation and public trust and ownership? We hold that MS Mahasweta Chatterjee is the owner of the property, let it be given to her.
I am not for that, my lord. I am not for that.
I think that's the
I am
only
for, I am that illegal, forcible illegal eviction is illegal. That was the case before the Honorable Single Judge.
So
That
therefore, let us await the result of the title suit.
actually what happened?
If the title suit is withdrawn and 144 proceeding has ended in no order being passed,
Yes.
then perhaps you can come. But
Hey,
at
what?
le-
Kindly
Mr.
allow me. Kindly allow me
you
one.
are a very seasoned advocate. You know so much of civil law. Please try and appreciate the difficulties of the single judge when you are addressing him. Now that was the time when the title suit was pending. 144, there was no disclosure by you what was the result, and there was an eviction because prima facie it was found by the authorities that it was a public trust. We have seen this. You
There,
made
there I,
just
there I raise my
try
objection.
and hear the bench so that you will know that we are not missing any fact. You came before this court saying that look here, it was a structure which was being let out for marriages, and in support of that statement you also gave an order of the court whereby you had challenged the decision
Somebody
of the
else.
pollution control board for stopping all such proceedings. We have seen everything in the order. Now therefore this was the only order which could have been passed on that occasion. With a title suit pending and 144 proceeding remaining inchoate, where could you have expected an order from a single judge under 226 to restore the possession of the land to you? And therefore we don't find fault with the learned single judge's order. It's so simple.
Now, my lord, kindly allow me one or 2 minutes. I will
Yes.
place before your lordship the subsequent development. Actually, my lord, during the after filing the title suit, title suit was filed on 3/7/20, and on 4/8/20, the same plaintiff filed a petition before the Chairman Religious Trust Board for declaring the trust property as public trust. And on the same day, that is on 4/8/20, the chairman declared the property as public trust property and directed to get it registered.
Local person is involved, some minister is involved. नहीं नहीं, हम दूसरी बात कर रहे हैं, इंटरफेयर नहीं कर रहे, वो तो हम समझ गए, लेकिन लगता है कि जैसे ही ये होगा उसके बाद कभी एक ट्रस्ट के लिए समर्पण. Now where is that samarpan nama? Have they placed it on record?
Actually, practically my submission is that if your lordship kindly come to paragraph 9.
Just a minute. We are only trying to find out whether you are the rightful owner or not. Now, have you implemented those persons, those who had shown samarpan nama on the basis of which they were thinking?
That is a matter to be adjudicated by the civil court. Now they have filed a petition for withdrawal. That is why I was trying to state the facts before your lordship. After the order passed by the chairman board, this petitioner came before this Honorable High Court for quashing of that order.
Oh, achha,
yes, your lordship decided that matter. Your lordship decided that matter.
And what did I do in that?
My lord?
What did I do?
Quash the matter. Set aside the order. Set aside the order, and now what has, and during the course of argument, the counsel appearing on behalf of Deepak Agarwal sought permission, liberty from your lordship to withdraw the suit, and thereafter pursuant to that, and your lordship granted the liberty, and thereafter they filed a petition for withdrawal of the suit. That is pending. That is pending. Not yet, the order has not yet passed in that suit. That's all. That is the position. Now, my lord, what is my submission is that it is only then
there would be another aspect to this story. Now, this withdrawal effort, the effort at withdrawing is for the purposes of securing the possession of that land as a trust. Now, instead of going to, I mean, you can also challenge the order of the Bihar State Religious Trust Board declaring the property as trust before the civil court. They are intelligent people. They have got an order of the religious board that this property is a trust. Now they would not like to have it confirmed or tested in the civil court, where both sides would have the liberty to file documents. Now their job is over. You challenge that order.
No, there is further development also, and there is an observation by your lordship in that order that if the board is vested with the so much of power to hear the case for deciding the nature of the trust, then the board can proceed. And taking the advantage of that, they have issued notice and started hearing of the case by the chairman of the board has started issuing notice, and he is hearing the case.
Notwithstanding those facts, now we here cannot direct. Suppose this court was a single judge's bench. Even then, I would not have passed an order. Even then, even with this development, we would not have passed an order. For that, you would have to be compulsorily relegated to another authority.
Well, kindly appreciate one thing I will submit for your lordship consideration. It is only a title suit filed, no other petition, no order. And if your lordship comes to paragraph 9 of the impugned order, That is page 6, internal page 6.
Yes.
My submission is that by the observation that the as it is clear from the pleading in the writ application itself that a suit in respect of the said properties pending before a court of competent jurisdiction asserting therein that the said Manbhari Kumar had executed Samarpan Nama.
So this that's all right.
So my lord,
It's one
yes,
and
my
the same
lord,
thing. देखिए समझ गए आपकी आपकी आर्गुमेंट हमने समझ ली ये
जी.
सब ऑन द बेसिस ऑफ दिस समर्पण नामा ऑफ 1952
That is an I dispute that.
you may dispute but
That will
therefore
be adjudicated before the court.
yes
That will be adjudicated. I dispute it. My submission is that that is a forged. Manbhari Kumar died in the year 1948.
they have followed it.
Yes.
Now MS Chatterjee, what will prevent you from challenging any order passed by any authority which has wrongly relied upon this document? ये हम नहीं करेंगे. The under Article 226, you are aware of the contours of the powers of a judge under 226 and an appeal under clause 10.
What are you? Why I placed this
आप
paragraph number
हमें
9?
डिस्ट्रिक्ट जज बना देंगी तो बड़ा मुश्किल है.
Some protection that this
What
is
protection? Tell
highly,
us.
highly
I can see
arbitrary
this.
action.
I can, MS Chatterjee, you know, I was only consulting with my brother. I can see something happening beyond, you know, the powers. But you see, you were evicted. The a local MLA and minister was involved. We see something here. But the difficulty is that once a petition has been filed, a statutory authority has also decided wrongly relying upon a document which you can challenge and you have the forum to challenge. Now, how do I find fault with the learned single judge who has applied his mind, has decided and has used and has pressed correct proposition of law? Suppose I were the single judge deciding this matter, what would I have said?
And
even when this fact would have been brought to the notice of the single judge that the suit is likely to be withdrawn, if the suit is likely to be withdrawn, that permission would always be granted for the reason that anybody who does not want to, who does not press his petition, he has the liberty to do so because it's a civil dispute. Now therefore that withdrawal would not prevent you from filing another suit challenging the reliance of any authority over a document which you say is a forged one. Your mother has, the document is said to be purported to have been executed by your mother, right? You would have every wherewithal to decide that to get it decided that it was not, it is a fictitious document. In fact, you would have been well advised. I don't know, I am rendering advice to you from the bench. Even when they had filed that title suit for declaration of the property as a trust property, you should have filed a cross suit.
Even counterclaim is seek and file. Even counterclaim.
now the matter is pending before the board for decision. He has
What?
again issued the.
Would you be satisfied by the decision of the board? Absolutely not. They would. Board has only the jurisdiction to see the document which is under dispute. What will the board say? What will the board say? Bihar State Religious Trust Board, it is vested with the powers of the civil court for many in many respects. But what would it say?
No, under section 28 to you whether the trust is private or public, that is the question.
That is the question
being
which they
proceeded.
can decide.
That
So
is,
if the matter is pending before the trust with respect to that also, they would have chosen to withdraw the suit for the reason that the board would have insisted for such withdrawal. I think that would be the reason. I don't remember. Are you in possession of the order which was passed by me sitting singly?
which was passed?
The permission to withdraw the suit in view of 28U of the Bihar State Religious Trust Board Act.
I have got it, but now it is not with me.
Let us. Can you
No,
just show it
not,
to us?
not
So
with me.
we grant you the liberty. You are not dependent on the liberty granted by the division bench. You go and contest that suit.
They will withdraw it.
No, contest that petition before the board. Contested
Anyhow,
before.
that is, in that petition I did, that is a different matter, my lord.
No, it's a very connected
Now,
matter.
what I was trying
Suppose
to,
that's not a different matter. Suppose it is found by the board that it is not a public trust, then would you not be
it
restored
is
possession?
not a public, nobody has declared the property as public trust as
Right.
yet. There is no such declaration.
Both in the absence of, we will have to await the judgment of the board, no?
That
आप
is,
कहिए, आप अपनी सूट फाइल करिए अलग से कि साहब ये सब अपनी चलती रहेगी, हमारा टाइटल है, this property has been purchased by from a Muslim gentleman by my mother and I have constructed the property over there. You are asking,
what I wanted to place before
why
your
don't
lordship,
you, this is Motihari, no?
yes.
You go before Motihari court.
What I
seek a
wanted to place
declaration.
before your lordship is that the admitted position, all are admitted position from the impugned order, your lordship
Who is
will find.
admitting? Who is admitting?
It is
Have you
from
just a
the-
minute?
from the
have
documents,
no,
nobody
no.
has disputed.
Have you implemented those persons? Anil Agarwal
Now,
and Dilip Agarwal.
what I am saying, that the sale deed, mutation order and LPC all are admitted fact, and there is no dispute over that. And my submission is that
Our
without,
suggestion to you would be that don't take an order on the merits of the case. You have a safe passage from the division bench to contest the matter before the State Religious Trust Board or go before the civil court for vindication of your rights. We can say this. Though that observation also would be beyond the scope of the clause 10.
actually, my lord, what I wanted to submit by, if your lordship peruse the paragraph 9 of the impugned order, by which my submission is, it is almost deciding the title suit.
No.
My lord, that is according
No.
to my understanding.
The learned single judge has been very cautious in framing his words.
My lord,
No.
kindly allow me to read.
MS Chatterjee, that is not correct.
Last para clarify this thing that he has not gone into merit of the case. Last para of this impugned order claims that it made clear that I have not gone into the merit of the claims of the petitioners in respect of the title or occupation in respect of the premises. So this
I
is
have
the answer to
authority
your
to-
question.
Now, what I was placing, I was trying to place that I did not have any, the title of petition number over the premises has been completely disputed. In the aforesaid background, one of the relief
As per the
sought
claim
for,
it is observed, as per the claim of the party, this is observed by the court. So your basic thing is that you are claiming title to the property and you want retention of the possession. So for that relief, this court is not meant for. You have to go to civil court.
you know, that was my submission as your lordship.
Heard, you want a detailed order?
It cost like case.
That's
You want a detailed order, MS Chatterjee?
my lord.
Do you want a detailed reason order? Or do we give you a liberty to go before the authorities?
Authority means the chairman.
And independently before the civil court? Take a call.
For the relief sought for in the writ application.
Whatever. Take a call. We can
The
give an
lordship
order.
may pass any order. Without instruction, I can say. The
Without
lordship may
this,
pass
it
any
will be
order.
safer. It will be safer for you to press this appeal, and I will
Yes,
pass
I
an
am.
order on merits.
Yes, sir.
All right. Heard, MS. That's correct. Otherwise, you may be misunderstood. Otherwise, you may be misunderstood. It's a heavily contested litigation. We will take it that you have pressed this
Actually,
appeal.
my lord, I have challenged that notice also because your lordship observed that if the board is vested with the power and that title suit has not been withdrawn, and he has, during the pendency of that title suit, notice has been issued. Therefore, I have challenged that also. The
Ready-made answer to ready-made answer to your detractors that attempt has been made, permission has been sought from the court, so therefore this is not challengeable. We will decide it on merit. Heard, MS Mahashweta Chatterjee, but I see that you have made great efforts In fact, it was not properly directed. Otherwise, by this time, you would have secured the possession of the first floor of your house. It was not properly directed. Anyway, heard MS Mahashweta Chatterjee, learned advocate for the appellants, and Mr. Saroj Kumar for the state. The appellants have challenged the order dated 10/3/2021, passed in CWJC number 8844 of 2020, whereby the learned single judge has refused to issue any direction to the respondents to restore to the appellants their possession over two-storied building standing over plots number 474, 472, 475, 447, 458, 459, 466, 470, 461, 462 and 471, which according to the appellants is their personal property, over which they have the right title and interest. The prayer made on behalf of the appellants for restraining the district magistrate East Champaran at Motihari from interfering with the said property also has been rejected. It appears that the appellants rested their claim over the property in question on the basis of registered sale deeds executed in favor of the grandmother of the appellant number 1 way back in the year 2014. First up.
1944.
2014 लिखा हुआ है. Way back in the year 1944. First up. 1944. Some of the persons of the locality, relying upon a document titled Samarpan Nama dated 8/4/1952, sought a declaration of the aforesaid property as a public/religious trust. It was the case of the appellants before the learned single judge that because of the interference of a local politician, the appellants were forcibly evicted from the premises. Notwithstanding the fact that that section 144 CRPC proceeding having been dropped midway with respect to the property. The learned MS Chatterjee, learned advocate for the appellants, has drawn the attention of this court to the fact that the learned single judge heavily relied upon the existence of the pendency of a title suit number 176 of 2020, seeking a declaration that the said premises is a public trust in which the appellants have been impleaded as defendants. MS Chatterjee has further argued that a simultaneous effort has been made by one Dilip and Anil Agrawal, one Deepak Agrawal and Anil Agrawal, to contest the matter before the Bihar State Religious Trust Board with respect to declaration of the property as a religious trust and not a private property. क्या लिखा पढ़ो? Last line. That proceeding also is still pending final adjudication. In the interregnum, we are of the considered view, no direction could have been issued under Article 226 of the Constitution of India for restoration of possession of the property in favor of the appellants. For the aforementioned reasons, we do not find any fault, we do not see any fault line in the order passed by the learned single judge. In view of the judgments of the Supreme Court in Union of India and others versus Gauss Muhammad, AIR 1961 SC 1526 semicolon DLF Housing Construction bracket private close limited versus Delhi Municipal Corporation and others, AIR 1976 Supreme Court 386 and semicolon State of Rajasthan versus Bhavani Singh and others, 1993 Supplementary 1 SCC 306 and State of Bihar and others versus Chandrabanshi Singh, 2015 SCC Online Patna 10048, which decries passing of any order under the writ jurisdiction in the event of basic facts being disputed and the claim of either of the parties dependent on complicated questions of law and fact involving adducing of evidence. In all the aforementioned cases, the line of reasoning, the consistent line of reasoning is that in such cases, the only right course for the High Court to follow is to dismiss the writ petition on the preliminary ground, without even entering into the merits of the case. The Supreme Court in all these cases has sounded a note of caution that not doing so would lead to a perilous and hazardous path, embarking upon a determination of the points involved with respect to the respective rights of the parties. The learned single judge appears to have, the learned single judge has taken note of all these facts, all these principles in not acceding to the prayer made on behalf of the appellants before it. We do not get, we have not been persuaded by MS Chatterjee to interfere with the order passed by the learned single judge. First up, the appeal therefore is dismissed. However, the appellants shall have the liberty to contest the matter before the Bihar State Religious Trust Board, as also to have their rights vindicated by approaching the correct forum to which they are entitled.
Actually, my lord,
Actually,
my lord, I don't want to contest before the Religious Trust Board also.
We have only given you the liberty.
Because my lord, according to my submission, that the under section 28(2)(u) of the Act, where there is a created registered trust, the chairman, the board can decide the nature of that trust only, and there it is a unregistered trust deed, and my submission is that is not a trust deed at all. Therefore, I have filed a writ petition also against the issuance of that notice. Therefore,
That's right, you contest
therefore,
that, or usko hata dijiye. Leave that. Leave that. The petitioner, the appellants, however, will be at liberty to have their claims and rights vindicated by approaching the appropriate forum to which they are entitled.
yes, ma'am.
All right, thank you.